SJC 12318, Commonwealth versus Cristian Rodriguez.
Good morning, Mr. Riordan.
Good morning, Your Honors. Theodore Riordan on behalf of the defendant, Cristian Rodriguez. In 1865, this court decided the case of Barber versus Merriam. The court held that it was well established at that point that a statement to a physician for purpose of diagnosis or treatment was a hearsay exception and could be admitted substantively. That was a medical malpractice case. That holding was subsequently implied in a CMP case in Michaud and in the criminal context in Comtois. And so the present state is that the Commonwealth routinely admits statements of alleged victims that were given for purposes of diagnosis or treatment. The issue before this court today is whether or not the statements of a defendant that are likewise given for diagnosis or treatment are admissible substantively.
So, counsel, really are you, in essence, arguing that there should be no difference between how we treat medical diagnoses of the body and medical diagnoses of the mind?
Yes. Yes.
But here, the reliability is different because it's in the forensic context, and the only reason you're being interviewed is to see what was your mental state, perhaps to see whether you're not criminally responsible. So how do you address that reliability issue?
Three responses to that. I want to cite to the Barber case itself. It has a very interesting quote on this issue. My point is that you could have a victim who has some motive to, against the defendant, or could want to exaggerate. Well, let me be clear about that I'm not asking the court to overturn the Nadi case law that talks about...
I'm not taking to it, because you're very... I commend you, because what you've done is taken an area that the 803.4 and trying to apply it, not to say we should overturn it, but to say this has not been decided by this court.
Exactly, yes.
As we didn't do in Hamey and all those juvenile and the Penadosi case.
Right, exactly.